Part 3. Reproductive Decision-Making. Intense Individualism. Our societies manifest intense individualism, including intense moral individualism. Francis Fukuyama. My preferences are my moral values. As a result, decision-making about life, reproduction, and death is seen as purely private. Pursuant to this view, those decisions are regarded as no one else's business, and certainly not the state's, especially to interfere with through law. This view would favor the state getting out of the marriage business, one of the options on your committee's agenda. But as Samuel Johnson said, marriage involves a third party beyond the man and the woman, society, and, if it be considered as a vow, God. In short, marriage is not just a matter of private decision-making. It is also of concern to society. That becomes most apparent when a marriage breaks down and ends up in divorce courts. If society has a valid interest in marriage, as I believe it does, it must remain involved in marriage through the law. Adult-centered reproductive decision-making. Our societies have also adopted adult-centered, as compared with child-centered, reproductive decision-making. Child-centered means, among other requirements, that we should work from a presumption that, if at all possible, children have a valid claim to be raised by their own biological parents. We must consider the ethics of intentionally creating a situation that is otherwise. It requires justification. There is an ethical difference between individuals choosing to create such a situation and society authorizing or facilitating it. While society would have ethical obligations not to interfere with the freedom of individuals in relation to reproduction, such to restrictions on the use of reproductive technologies discussed below, it also has obligations not to facilitate the creation of situations that are not in the, quote, best interest, unquote, of children. In short, the compliance of society in helping to create non-traditional families in which children will be raised is not an ethically neutral act. One common response to the position I outline above by those advocating same-sex marriage and families is to point out the deficiencies of marriage. This issue is not, however, whether all or most opposite-sex couples attain the ideals of marriage in relation to fulfilling the needs of the children they produce. Neither is the issue whether marriage is a perfect institution. It is, rather, whether we should work from a basic presumption that children need a mother and a father, preferably their own biological parents. I believe they do. The issue is also whether society would be worse off without the aspirational ideals established by traditional marriage. I believe it would be. Reprogenetic technologies. The combination of adult-centered decision-making and intense individualism, together with reproductive technology, can result in a claim of rights to absolute reproductive freedom. See John Robertson, University of Texas. In this respect, the judgment of Blair R.S.J. in Halpern et al. Versus Canada, Ontario Divisional Court, merits consideration. He addresses the argument that same-sex partners could not reproduce with each other and, therefore, that extending the definition of marriage to include same-sex couples was not justified. He rejected that argument on the grounds that same-sex couples could use reproductive technology to have children. It is relevant to note, first, that in so doing, the judge recognizes that a fundamental feature of marriage is related to procreation, and second, to the extent that the judge's ruling implies that people have a right to, quote, absolute reproductive freedom, unquote, it would mean that there would be duties not to interfere with access to reproductive technologies to make reproduction possible, or, for instance, with two men married to each other having access to a surrogate mother. There would also probably be a duty to provide access to the means for collaborative non-coital reproduction, procreation through the use of reproductive technologies. After all, if exclusion of same-sex couples from marriage is found to be discrimination by way of comparison with opposite-sex couples, not providing same-sex couples with the means for procreation, that is, excluding them from procreating with each other, when procreation is possible between opposite-sex couples, is a related discrimination. Indeed, the Nova Scotia Court of Appeals has held that failing to provide an infertile couple with access to reproductive technology was discrimination under Section 15 of the Canadian Charter of Rights and Freedoms, although justified, in that particular case, under Section 1 of the Charter, Cameron v. Nova Scotia Attorney General.